Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good afternoon. Our next case is State versus Garmon, and we will hear from the appellant.
Good afternoon, Your Honors. Mr. Chief Justice, and may it please the Court, my name is Zachary Dunn, here on behalf of the state. The Court of Appeals erred in granting defendants' motion for appropriate relief on the habitual felon issue because its 2012 opinion in Ross cannot survive this Court's opinion in Singleton. And in the alternative, the timing of a habitual felon indictment is not statutorily prescribed and has no bearing on its validity. Separately, the Court of Appeals correctly held that the evidence taken in the light most favorable to the state was sufficient to send the question of whether a defendant kept or maintained his vehicle for the purpose of keeping or selling a controlled substance to the jury. So at bottom, this court should reverse the Court of Appeals' grant of defendant's motion for appropriate relief and reinstate the judgments of the trial court below. On that first issue, Your Honor, I really want to start with the defendant's motion for appropriate relief, which was filed at the Court of Appeals. And on page 5, the defendant makes very clear that his argument was that the trial court lacked subject matter jurisdiction because of the timing of the habitual felon indictment. But 6 months before the Court of Appeals decided this case, this court decided Singleton. And in Singleton, this court unambiguously held that our Constitution and general statutes, not an indictment, confer the general courts of justice with jurisdiction over criminal laws, and that defects in an indictment do not deprive a court of its power to adjudicate a case. Critically, in this case at the Court of Appeals, the Court of Appeals relied on its own previous precedent, Ross, to hold that when an indictment is fatally defective, the trial court acquires no subject matter jurisdiction, and if it assumes jurisdiction, those convictions are a nullity. And simply put, Your Honors, that statement of the law does not survive Singleton, and so the Court of Appeals holding in this case cannot survive Singleton. Now, defendant's argument is that General Statute 14-7.3 is a jurisdictional statute, which takes it out of the ambit of Singleton and makes it irrelevant for the purposes of this case. That is simply incorrect. As this court held in Bryce in 2017, we know that to determine if a statute is jurisdictional in nature, we have to look at the purposes sought to be served by the enactment of the relevant statutory language. That's from Bryce. And Bryce is really important here because in that case, this court held that a very similar statute, 15A 928, was not a jurisdictional statute. And the court construed that statute to have basically two provisions, a separate indictment provision and a notice provision. And looking at this statute, 14-7.3, it essentially has those same goals and aims. There's a separate indictment provision and then a notice provision. It sets out what indictment must have in it, the date of the prior felony offenses, the date that the pleas or convictions were obtained, those sorts of things. And so as this court held in Bryce, these are not the sort of goals typically sought to be achieved by the imposition of additional jurisdictional requirements. So we would ask this court to hold that 14-7.3 is not a jurisdictional statute, which puts this case directly in line with Singleton. And the Court of Appeals erred by relying on its 2012 opinion in Ross to hold that the habitual felon indictment here did affect the subject matter jurisdiction of the trial court. If this court rejects that argument and finds that Singleton does not apply or directly control this case, the Court of Appeals nevertheless erred in holding that a habitual felon indictment must be filed after the substantive felonies. And this rule, first, is atextual. If you look at 14-7.5 or 7.3, there's nothing in that statute that sets out when a habitual felon indictment can be returned, whether it has to be before or after the substantive felonies to which it attaches. Nothing of that nature is in the statute. Second, the Court of Appeals created this rule out of whole cloth in Ross and one of its prior opinions, Flint 1 from 2009. And in Flint 1, the Court of Appeals relied on its previous precedent. So we're going from Ross to Flint 1 back to Blakeney. And in Blakeney, the Court of Appeals held that a habitual felon indictment may be returned before, after, or simultaneously with the substantive felony indictment. However, in Ross, the court held that it is difficult to see how the habitual felon indictment could not attach as ancillary to felonies that had not yet occurred. So this was an incorrect ruling by the Court of Appeals in 2012 that has perpetuated itself up to and including this case. And we would ask this court to overrule Ross and hold that even if this is a jurisdictional question, that the statute in question, 14-7.3, does not have any requirement within it that mandates the timing of a habitual felon indictment with respect to the timing of the substantive felony indictments.
Can I ask you a question about the record or the absence of material in the record? If one were to just review the materials, or at least what I saw in the record here, you could perhaps surmise that the prosecutor in January of 2020 was simply creating habitual felon indictments for no other purpose other than to put a defendant on notice that he was an habitual felon. Were there other charges associated with that indictment, or because there's an absence of information in the record?
That's correct, Your Honor. There's an absence of information in the record. I don't, stepping outside of the record, I'm not sure. The only indictments we have are the 14 January 2020 indictment for habitual felons, and then the substantive felonies were indicted on 14 January 2021, so exactly a year later. So why the district attorney or assistant district attorney chose to indict the habitual felon, chose to get that indictment returned in January of 2020 is unknown. But really, the purpose of the statute, 14-7.3, is a notice requirement, and make sure that the defendant is on notice that he's going to be treated as a habitual felon, and the indictment in this case in January of 2020 put him on notice roughly 9 months before he actually committed the substantive felonies, that if he committed substantive felonies, that the state would seek to treat him as a habitual felon. So given the atextual nature of this requirement about the timing of the habitual felon, and that what happened here did serve that notice function, we would ask this court to reverse the Court of Appeals on that issue.
Right, and that's what Singleton says, one of the purposes of indictments is to place the defendant on notice.
Correct, yes, absolutely, Your Honor. We do agree with that. One final point on the habitual felon indictment issue. In its briefing, the state has advanced an argument that a habitual felon indictment is not required to treat someone as a habitual felon. And I do want to make clear that this argument is wholly separate from the other two arguments, from our Singleton argument on one hand, and even if Singleton doesn't control, our argument that the statute doesn't require the specific timing for a habitual felon indictment versus the substantive felonies. But we do bring this issue to the court for several reasons. One is the way that the statute reads and includes permissive language, may versus shall or must. And two, that the use of the term indictment in this statute is a curious choice by our General Assembly, given that a habitual felon is a status rather than a crime. So normally indictments are used to charge someone with a crime. However, here habitual felon is not a crime at all, but rather essentially a sentencing enhancement status. And finally, a literal reading of the statute would foreclose the use of, for instance, informations to charge someone as a habitual felon. So really, this is an issue, of course, it's wholly separate and apart from our Singleton issue and our issue about the nature of the statute itself. But we did want to bring it to this court because, some statement by this court about what the statute requires, whether an indictment is needed, would be helpful for assistant district attorneys and district attorneys throughout the state in how to charge these crimes. So that's all I have to say on that issue, Your Honors. I would like to turn to the argument of the sufficiency of the evidence for the keeping or selling of a controlled substance. And here we're only discussing the fourth element of the offense, which is that defendant's vehicle was used for keeping or selling of a controlled substance, which here was fentanyl. And really there are two seminal cases from this court on that point, or on that element, which is Mitchell on one hand and Rogers. And in Mitchell from 1994, I believe, in that case the defendant possessed marijuana, a controlled substance, while in his car, and then the subsequent day another marijuana cigarette was found in his car. And on that evidence, this court held that an individual within a vehicle who possesses a controlled substance, that cannot establish that the vehicle is used for keeping the controlled substance. And so really just the fact that a controlled substance is found in a vehicle is not enough, and we have to focus on the use and not the contents of the vehicle. And then on the other hand, we have Rogers, which is from 2018 from this court. And in that case, the contraband, the controlled substances were found in the gas cap of the vehicle. And this court held that a defendant who stores contraband will, all other things equal, want to store it in a hidden place, which is exactly what putting cocaine in the gas cap compartment would accomplish. And so really we're focusing not on the contents, but on the use of the vehicle. And one indicia of the use of the vehicle may be where the controlled substances were stored. And in this case, we have fentanyl, which was found in a backpack on the floorboard of defendant's vehicle. And while a backpack is different in kind from a gas cap compartment, it still shields the controlled substance and from view and represents a hidden place that would not be readily apparent from an outside viewer. But in addition to the exact location of the fentanyl in this case, in the backpack on the floorboards, we also have other indicia of how this car was used in this case. The first being the information that the officers received from the confidential informant, and this is really on pages 257 and 262 of the transcript. The officer explained that a confidential informant had alerted the officers to a small silver car with damage on it, which ended up being defendant's car, and the confidential informant was giving information about interdiction investigation. So that's another piece of evidence, and in addition to that, we have the statement of the officers, which recounted the statements of the defendant in this case. And the officer testified that, when he was talking to defendant at the scene, he told him, if it's just a revoked license or driving without a license, I'm not going to put you in jail, things of that sort. And defendant responded, that wasn't it, and he had to make money somehow, and that he knew it wasn't right, but I just do it for my kids. And so that is evidence of how this vehicle was being used. Defendant certainly wasn't using the fentanyl himself to help his kids. The jury could surmise that he meant he was selling the drugs or keeping the drugs in the car for the purposes of selling the drugs. So with all that evidence and the standard to be applied here, which is in the light most favorable to the state, and we're only looking for substantial evidence, we would argue that the Court of Appeals correctly held that the trial court correctly denied defendant's motion to dismiss on this issue.
I understand that the police officers found a motel receipt from the night before. Is that correct?
I believe that's correct, Your Honor. And that would add to the sufficiency of the evidence claim. That is some evidence which can go towards the substantial evidence test here. There was also a white powdery substance found in the cup holder of the car, so that's even one more point that led to the sufficiency of the evidence being enough to get past the motion to dismiss and submit the case to the jury.
So in
So that fourth element can be satisfied by either keeping or selling. In Rogers, if I understand correctly, the court said we're only going to look at the keeping element, or the sub element, if you will, because the Court of Appeals decision focused on that.
I believe that's correct, Your Honor.
Are we in a similar situation here?
I think so, Your Honor. This evidence does tend to support a finding that the defendant was using this vehicle for keeping drugs. However, this court could hold, in that sub-element also the selling portion, and that would go towards not only where the backpack or the fentanyl was found in the backpack on the floorboards, but also defendant's testimony, the officer's testimony about what defendant said during the traffic stop, which is that he knew it wasn't right, but he was doing it for his kids. That could be used as selling towards the selling element.
I guess what I'm getting at is if we go to the selling sub element, are we going beyond the scope of the dissent?
I think that's possible, Your Honor. I think the dissent only focused on the keeping element. It would be an alternative basis for this court to affirm the judgment below on this point, and we think that the evidence presented is sufficient for both the keeping or the selling. So if Your Honors agree with us on the keeping sub element, we don't think that Your Honors, this court, would have to go any further. But I think you are correct that the dissent did focus on the keeping element. Those are all the points that I had to make, Your Honors. Unless there are any further questions, I will reserve the balance of my time for rebuttal.
Thank you, counsel.
Thank you.
You're from the appellee.
May it please the court, my name is Jarvis Edgerton and I represent defendant appellate Mr. Charles Garmon. I guess we'll jump right into it. The state makes the argument that Singleton applies to this case. In my brief, I make the argument that it does not. This is a statutory jurisdiction scheme. It is not a common law jurisdiction scheme. Singleton on its face makes fairly clear it is talking about common law indictment rules. And in fact, Singleton distinguishes general statutes from what it's talking about on its face. Unless there's any questions, I really don't believe that Singleton is an issue in this case, and I'm happy to answer any more questions this court might have about that. The state talks about the plain language of the statute. I'd like to get directly into that. And as soon as I find a copy of the plain language, I will do exactly that. Here we go. An indictment which charges a person with being a habitual felon must set forth a date that prior felony offenses were committed. Names, that's not the part I'm looking for, but I will talk about, the statute talks about an indictment and it says there must be one. I think that's fairly clear on the face that this is a statutory jurisdiction scheme involving an indictment. I'd like to point out that this statute was written before Singleton. And at the time, the understanding of what indictment meant and how they were subject matter jurisdiction, how they were the basis for subject matter jurisdiction was not challenged by Singleton. And in a memorandum of additional authority, I put up some law about legislators presumed to know the existing law and legislate with reference to it. State v. Rise Company and then Accord and State v. Davis. That's what happened here. When they're talking about an indictment and how it must be done to confer to support the conviction, they're talking about the old view of indictment, the view of indictment that existed at the time the statute was written. And that was the indictment conferred subject matter jurisdiction. And if it didn't, it could support the conviction. And that's the language of the statute. There has to be an indictment. If the indictment's not well done, not properly done, it does not support the conviction. It's defendant's position. This is clearly a subject matter jurisdiction statute created by the General Assembly. It is not from common law. It is how the General Assembly, in its discretion, chose to approach this issue. And if, as the Court of Appeals suggested, maybe there's grounds to make material changes to that statute. If there are, that's for the General Assembly to do. That's not for this court to do, because this court doesn't write statutes. Now, if there's room for interpretation, there's room for interpretation, but I would submit there's not. It clearly calls for an indictment, and it clearly says it doesn't support the charge without the indictment. I think that language could not be more clear. And that's defendant's position about the plain language of the indictment, whether it's subject matter jurisdiction, and whether these things are required or not. And this gets to whether this is subject to harmless error, which I think is what the Court of Appeals was getting to. Under the statute as written by the General Assembly, this is not a harmless error situation. Either it's right or it's wrong. If it's wrong, it doesn't support the conviction. That language very clearly forecloses, in defendant's view, an application of harmless error to this case. And I wanted to get that out. During its statement, the state conceded that the statute requires an attachment of a habitual felon to an indictment, to the substantive offense indictment. I agree with the state that this is a notice statute, but it's not just notice that the defendant has committed 3 prior felonies. It's notice that the state, the prosecutor, is applying the habitual felon enhancement to a particular substantive felony. And that's the notice that disappears under the state's way of approaching this. Yes, you can put an indictment out and say they've been charged with these 3 felonies, and that doesn't change. But what does change is whether that applies to the substantive felony being charged in each particular instance. And that's why they have to attach. And I think the statute, if you read it, seems to be getting at that. You know, it has to attach so the defendant knows that this habitual enhancement applies to this particular charge. And that's what they're getting at in Ross. You know, obviously that notice doesn't exist if the habitual felon predates the substantive offense indictment. That habitual felon indictment does not tell you we're charging this as a habitual felon under those circumstances. It fails to provide the notice that I think that the General Assembly was trying to have the statute do. Now, I'm not going to argue this is the best written or clear statute, but I think that it is fairly clear what their intent was, and that everything I'm hearing about changing it undermines that intent. The intent to put the defendant on notice that the state is charging this felony as a habitual felon. And that allows the defendant to make prudent choices during plea bargaining and know what to argue at trial. Like, for example, if the state is allowed to put forth the habitual felon indictment and use it for all subsequent felonies, there's nothing that stops the state from putting you on trial for a substantive offense, and after the jury verdict going, I really didn't like how the defendant's trial counsel handled this trial. We're going to go ahead and make it a habitual too. There's no protection from that unless you attach them together and from early on in the process, link them up. So this, I don't know if I called it sandbagging in my brief, but that's pretty much what the state is opening the door for here. And I don't think that's good jurisprudence, and it's certainly not fair notice under the 6th Amendment of the Constitution if you don't find out about it until after the convictions already, for the substantive offense, have already occurred. I hope I've explained that well, but the key point I want to make is the notice that's important here is the linking of the two, because the charge is discretionary. So any sandbagged indictment does not provide the notice that matters here. Of course, they still have committed 3 felonies. That's not the question. The question is, are these 2 things being linked together? And I think that's why the court and Ross, or the court and Ross and the General Assembly wrote these statutes the way they wrote them, to provide that particular notice. Could it be clearer? Perhaps, but that's something for the General Assembly to decide. if they want to revise that statute in a material way. The question about other charges. That is a good question. I apologize that I did not put that stuff in the record. My take on this was that there were charges and habitual felon indictment. Then COVID hit, and there was this long period of time where there were no trials. And so new charges came up, and the state just recycled, the prosecutor just recycled the old indictment and applied them to the new charges. That's my understanding of how it happens. I realize that's not in the record, but if you look at the timing, that appears with the gap during COVID to be what happened. It was, an honest mistake. The state wasn't aware of the implications of doing that. They could have written a new indictment. I'm not going to blame them for not writing it. Apparently not every prosecutor understands the way this, knows about Ross and understand how this works. But that's how I think this came to be, was because of COVID. That's defendant's perception from what I've read. I've already talked about how the discretionary part of the statute is important, and that's what we're really talking about here, and why the statute has that ancillary, and why the habitual felon indictment cannot predate the offense. Because if it does so, it does not provide notice that the state is applying that habitual felon indictment to that particular substantive felony. And that's the key point I want to make about that. The statute does serve a purpose. It serves a very important purpose. It serves a notice purpose, and the way it's written serves that notice purpose, and all the changes people are talking about take that protection out. I'll move on to the maintaining issue, unless any of you have questions about the habitual felon. All right, the maintaining. This is an interesting case. The state and the defendant are completely in agreement about what the law is. The state and defendant are actually in complete agreement about what the facts at trial were. What we're not in agreement about is whether certain inferences are reasonable inferences, or rather they're conjecture and speculation. That's really what this point comes down to. Now, like, for example, the state talks about well, let me make sure. I want to make this point before I forget. The state conceded that this is only about storage, not about selling. I agree with the state on that point. This is not about evidence of selling at this point is not going to cut it. It needs to be evidence of storage. I apologize, I don't have the record on appeal in front of me to look directly at the indictment, but in the Court of Appeals, there was no discussion about selling. That was not an issue that survived over to for this appeal to the North Carolina Supreme Court. The state and I are in agreement about that. I believe, Justice Newby, you asked about a receipt. Yeah, there's case law where a receipt is cited as a relevant consideration, and in this case, there was a receipt, but the details matter. And let me get my listing of cases so I can walk through that. The maintaining cases. If I recall correctly, the one about the receipt was the one with the car carrier, where the drugs were found in a car, inside a car carrier, and there was evidence that the defendant had possession of the car carrier with the cars on it over a course of several days and stopped at a hotel overnight. And when they talk about that in the case, they're talking about that showing this was not a continuous act of transportation. This wasn't like the instant case where you have evidence of 5 minutes, and during those 5 minutes, the only thing law enforcement saw was defendant driving. There's no evidence that he did anything other than drive during those 5 minutes with this vehicle and those drugs. Unlike the case where they're talking about the receipt, that evidence of the hotel stop, while in continuous possession, shows the defendant left the stuff in the car carrier, went into his hotel room, spent the night, came out. Obviously, the drugs were being stored in the car carrier during that period of time. That's how I understood the receipt evidence to be relevant. in that case. That's not the situation here. Yes, they found a receipt that he was in a hotel room, but it is speculation and conjecture to say that he had the drugs in the car and had that car at the hotel room or any of that. That's beyond what would be a rational inference based on that receipt. And I just want to make that clear, how the receipt was used in the prior cases and how it doesn't apply in this case, because it does not show the same thing within the totality of the circumstances. And I want to talk about these other cases, because like I said, this comes down to whether an inference of storage is reasonable here. If you look at all the other cases, there's exactly one case where there's no evidence of storage, and that's Mitchell. You know, the guy had it in his pocket, got out of the car, he had it in his pocket, no reason, no basis whatsoever to believe that there was any actual storage of the drugs. And the defendant won, Mitchell. You look in all the other cases, there is something. In Hudson, the car carrier case, there was the receipt showing the non-continuous transportation over a period that he was in possession. That's evidence of direct evidence of storage. He got out of the car, he left it in the parking lot, he got back in. It's a reasonable inference of storage there. But there's specific evidence on which that reasonable inference is based. State v. Rogers. Suspect was at a hotel room. Searched the car pursuant to a warrant, gas cap. The fact that the drugs were found in the gas cap. That's evidence of storage. And a country miles difference from a backpack within arm's reach of a defendant in a car, where the evidence is the defendant was in the car for 5 minutes and he was using the car to travel during that 5 minutes. You know, we talk about the totality of the evidence. Well, we've got to talk about the totality of the evidence, not just particular things. 5 minutes in a car, as observed by law enforcement. Drugs in a backpack. A backpack, in the Court of Appeals opinion, I understood them to be saying there's no difference between storing drugs in a false bottom tire sealant and storing drugs in a backpack. They say, well, you know, they're both containers, you can both move them. I think that glosses over the point. You know, the question here is there evidence of storage? And inside that the vehicle was being used for that, for the storage. A false bottom tire sealant, you're hiding it in the tire sealant, but you're also hiding it in something that is innocuous inside a car. When you look inside a car, you see a can of tire sealant on the floorboard. You're not thinking, wow, there's something in there I need. So it supports the idea it's being used for storage. You walk by a car, you look in, you see a backpack just sitting in there. You know, there might be something worth stealing there. I submit there is a real difference, and both the state on appeal and the state here and the Court of Appeals in its opinion just glosses over this when it seems to say that there's no difference between a book bag and a can of tire sealant. Yes, they're both portable, but that's not all. That ignores the totality of the circumstances to reach that conclusion. It's essentially willful blindness to the very distinct differences between those two things. And I would hope this court would not sign on to something like that, where you pretend there's not a difference between storing something in a can of tire sealant and storing something in a book bag, when the question you're trying to resolve is there any reasonable inferences to be made that the defendant was using that car to store those drugs? I really think there's a huge difference there. And I think that it's not being addressed. Let's see, Dunstan. In Dunstan, it was actually evidence that the defendant was selling out of the car. That was a 2017 case. Alvarez, there was buy-bust operation. The drugs were found in a constructed false bottom container inside the back of a defendant's truck underneath a bunch of tools. Yes, you could probably have moved the false bottom container. Could be portable, could have been picked up and pulled out, but you would have had to move all the tools off of it to get to it. Again, the idea that there's an equivalency between a backpack and a container hidden inside the bottom of a truck underneath a bunch of tools on the question of whether the vehicle was used for storage is not credible. There's clearly a difference, and I don't know how else to explain it other than it's just common sense. Let's see. Hudson was the car carrier, Mitchell. So what I'm trying to say here is you look at these cases, all the cases finding the evidence sufficient that we talked about or in the briefs or whatever, you can point to something in every one of those cases and say, you know, that's why we can make a reasonable inference that this car was being used for storage of controlled substances by this defendant. In Mitchell, you can't. There's nothing to point at like that. And I submitted in the instant case, just like Mitchell, there's nothing like that. You have to speculate and conjecture your way into storage with the facts that are presented here. Is it possible that the defendant was storing drugs in his car? Absolutely. But have you presented any evidence to support a reasonable inference of that? Sufficient that you're going to put this guy in prison for it? And by the way, he is in prison for these actions already. He was convicted of transporting these drugs under the exact same facts, using the exact same facts. It's not like this guy is getting away with anything here. The question is whether this additional crime is an additional crime or whether it's just punishing for the same behavior a different way. And I submit that it is punishment for the same behavior a different way. And that's exactly what this court in Rogers and this court in Mitchell says you can't do. The General Assembly did not intend for this to be just another add-on to the trafficking charges or trafficking convictions. There has to be more because this is more. This is another crime, and so there's got to be evidence of the elements of this crime. And the element of storage is where the state's evidence falls down here. Because unlike the other cases with convictions, there's nothing you can point to that creates a reasonable inference of storage. As I mentioned in the brief, you've essentially got an inventory list here. They list all the things that are in the car, but they don't talk about how Rogers and a number of other cases say that unless that evidence shows the car was being used for storage, it doesn't get you across the line. The state and defendant agree on this law. I believe the state cites that in its brief about how the contents are, unless they show it's used for storage or not dispositive. So then you get to, well, what else is there here? Okay, we've got a CI saying the defendant was driving a silver car with a dent. I'm at a loss to understand how that shows it supports a reasonable evidence the defendant was storing drugs in the car. Does it support a reasonable evidence that it's defendant's car or that he maintained the car? You know, yes, but that's not the element we're talking about here. The element is, does it show that the defendant was using the car for storage? And the fact that the CI said defendant is driving a silver car sheds zero light on that. To get from that to storage is speculation and conjecture. It's not a reasonable inference. Again, with the statement of defendant, I got to make money for my kids. Well, you don't make money storing drugs in your car. You make money selling them. So the implication that that is an admission that he's guilty of maintaining a vehicle, you know, that's quite a stretch. Again, speculation and conjecture as opposed to a rational, reasonable inference. Trying to think if there's any other evidence cited. Let me look real quick. I think that's largely it, if I recall. Let me look at the opinion, because I know in the opinion the court does a paragraph where they list all the evidence that they say supports it. And I want to make sure I'm not missing anything. Keeping maintaining a vehicle. Talks about how defendant principally relies on where the vehicles were hidden. That's actually not true. I did exactly what the law says. I took the law, I took the facts, I compared the facts to the law, and asked whether these facts support a reasonable inference as the law requires. Whether the drugs were hidden or not within the totality of the circumstances is a factor. Defendant is not saying it's the only factor, it's the main factor. That's just not defendant's argument, even though the Court of Appeals wants it to be defendant's argument, because that's easier to rebut than to actually get into these facts and explain how each set of facts either supports or doesn't support the inference. Defendant is not arguing for a blanket rule that a container has to be attached to the car, has to be hidden, any of that. Defendant's position is exactly what the law says. Within the totality of the circumstances, is there evidence that supports a reasonable inference of storage? And the answer is they're not. I consider that whole hidden or not, transportable or not, really kind of a distraction from the facts in the law, because I think the facts in the law do not support the position of the Court of Appeals. Essentially, I believe I called it a red herring, and that's how defendant understands that whole argument. It is not actually an accurate description of his argument. I am struggling to find where they list all the stuff. Oh, here we go. Handgun. Okay, again, the handgun under the seat. Is that evidence of general lawlessness? Perhaps. Is that evidence he was storing fentanyl in the car? I think that to get from the handgun under the seat to the defendant was storing fentanyl in the vehicle is speculation and conjecture, not a reasonable inference. General lawlessness does not prove the specific fact of storage. White powder inside the cup holder. Again, how does that prove that the defendant was using the vehicle to store controlled? Indeed, that would suggest the exact opposite. If he's storing controlled substances in the vehicle, he's not going to have them where you can look in and see it in the cup holder. I don't think that evidence supports the state's position. I don't think that evidence supports the Court of Appeals position. And I don't see why it's listed as within the totality of circumstances as support. Evidence located in the book. Okay, this is what they say. The evidence located about the vehicle, including the book bag and its contents, and all reasonable inferences to be drawn thereon from, support their case. Well, they say that, but they don't really talk about how these inferences, they don't get into the details here, and the reason they don't is because when you look at the details, that sentence is unsupported. I want to make sure I'm not missing something here about facts, because I think that's crucially important here, because that's what we're talking about. Do the facts support the charge? And I want to and because the state gets the reasonable inferences, I want to make sure I'm not missing something. Deployed a drug interdiction team, the CI, defendant didn't have a license, canines found alerted to the drugs, handgun in the passenger seat, book bag with items in them, including a scale, marijuana grinder, plastic bags, baggy corners, leafy green substance, scattered about the car, handgun, folded piece of paper with the white powder. The white powder was not identified. The Court of Appeals did not rely on it, so it's not available for this court to rely on it either, based on the that fact that we're talking about, the Court of Appeals opinion. That's it. So, I mean, the question is, where amongst that evidence is any basis to conclude that the defendant was storing the drugs in his car? And I submit there isn't. What you have there is an inventory, and then you have a bunch of additional facts that don't actually add anything one way or another. You've got the inventory, which is not dispositive because it does not in any way show storage. Or, well, it's relevant for sure. Like the case says, this is relevant, but it's not dispositive unless it actually shows, supports a reasonable inference of storage. And in this situation, it doesn't. It's just not there. You know, could he have been storing? Yes. Could he have not been storing? No. You just don't know from that evidence. And then you look at all the other evidence they put in to buttress it, and it's just general lawlessness evidence. There was a gun, there was some drugs, there's some white powder, there was an interdiction, the dog smelled contraband. None of that says anything about storage. And so the evidence is just insufficient here. When you look at the cases, you look at what these other cases relied on in their holdings, and then you compare those cases and those facts to the facts of this case, defendant's position is it seems fairly clear that this is a Mitchell case. This isn't a Rogers case or any of the others, because in all those other cases, there was something you could point to that was actually supported a reasonable inference. And in this case, there's not. There's just an inventory and some general lawlessness stuff, none of which is clear, none of which serves as a rational basis, supports a reasonable inference of storage. I have a minute 52 left, but I don't want to just repeat myself from the brief. Unless there's other questions, I will just end. Or I'll stand here for a minute and 42 and see if you'll think of any.
Thank you, counsel.
Thank you.
Rebuttal.
Thank you, Your Honors, and may it please the court. I have 3 quick points on rebuttal. The first, regarding the habitual felon indictment and the statute. Defendant claims that indicting as a habitual felon after the substantive felonies allows the defendant to make prudent choices during plea bargaining, but he doesn't explain how indicting someone as a habitual felon before the commission of the substantive felonies does not have that same effect. And in fact...
but can't you see the... I think it was a compelling point about how this could be misused if the new rules, they don't have to be attached. And so the hypothetical that your friend offered is, someone goes to trial on a certain number of felonies, is convicted, and then the state decides after the fact, for whatever reason, that they want to add something on. I mean, it seems like the rule, if the two aren't required to be joined, if the habitual felon charge doesn't have to be ancillary, that would be okay.
Well, Your Honor, we are not arguing that the habitual felon indictment does not have to be ancillary. We're just arguing that the timing of the habitual felon indictment has no effect on that. Once a trial begins and the state stands up and says, we're going to trial on these felonies and as a habitual felon, then that habitual felon indictment would attach and be ancillary, I can't say that word today, to those charges and in that trial, and that would be that, essentially. We're not arguing that one habitual felon indictment can be used for all time, or the state can game the system and decide when the habitual felon charge would be added to certain crimes. It's just that the timing of the habitual felon indictment itself, the fact that it predates the commission of the substantive felonies and the indictment of the substantive felonies has no effect on the trial court's subject matter jurisdiction. And so, yet once the substantive felonies are charged and the trial begins and the state says that we are going forward on this habitual felon indictment along with these substantive felonies, it becomes part of that case, and it can't be, there's no gamesmanship involved there, would be our point.
Well, if I can just follow up on that. So, and I'm trying to understand what would be consistent with the statute. And so then is it the state's position that this indictment that was returned in the date that I see on page 12 of the record says 1/14/21?
I believe 1/14/21 was the indictments for the substantive felonies, and I believe the habitual felon indictment was exactly a year later, 1/14/20. I could be wrong about that. I don't have it in front of me.
Because it also, well, I'm struggling with, is it your position that there had to be some subsequent, based on the face of, I'm sorry, I'm looking at the wrong indictment. My apologies. The habitual felon indictment says 1/14/2020. Yes.
Yes.
Okay. My question is, it's the state's position that on 1/14/2020, they could not proceed under this indictment because there was no pending felony that was being charged,
Absolutely.
based on what we know in front of us.
Yes, Your Honor, that's absolutely correct. I think Allen says that from this court. That indictment, it's a true bill. It is a pending indictment, but it could not attach until there are substantive felonies.
Right.
So the state could not proceed simply on the habitual felon indictment.
But there was nothing to prevent the state from obtaining after the 2021 offenses, the first indictment I read the date
Yes.
from,
Yes,
after
Your Honor.
that, there was nothing stopping the state from getting another indictment charging habitual felon.
There's nothing stopping them. Our only point is there's nothing requiring them to do that. Essentially, because this rule in Ross and Flint is based on subject matter jurisdiction, that the trial court did not have subject matter jurisdiction over the habitual felon indictment because it predated the substantive offenses. And we're saying, based on Singleton and the language of the statute, which does not say, it's atextual to say that it must post-date the substantive felonies, that rule is wrong, and the state was able to proceed on this habitual felon indictment after the substantive felonies were charged and went to trial.
Well, I agree with you that the statute doesn't so 14-7.3
Yes,
doesn't explicitly say, have a timing, but there's certainly an implication in the second sentence. An indictment which charges a person who is a habitual felon with the commission of any felony must, in order to assign a conviction of habitual felon, also charge that said person. So it does seem that at a minimum the statute is connecting the two.
It is absolutely connecting the two, and I think that was this court's point in Allen, that the state cannot simply proceed on a habitual felon charge. We agree with that, but there's nothing in this statute or this court's case law that says that a habitual felon indictment cannot predate the substantive offenses. Once those substantive offenses are charged and the trial begins, that habitual felon indictment attaches to those charges and can only be used for those charges. So that would be our submission on that, Your Honor. And I've already, in talking with Justice Riggs, but I want to make the point again, the state does not contend that there can be one single habitual felon indictment for all time. After the defendant's third felony, which would make him or her a habitual felon, the state cannot simply do one habitual felon indictment and use that to attach to every single substantive felony that the defendant commits. So I just want to disclaim that. We disclaimed it in our reply brief, but I did want to make the point here. And then one final point on the storage versus selling point. We think that the evidence is more than sufficient to get to storage here for all the things that we've discussed. But I do want to make the point, defendant disclaims that the state must show something other than, storage in a hidden place, in a gas cap or in a false bottom. But really what he's saying is that is something that must be shown if the court would accept his argument. I mean, it would be a message from this court that if you want to store drugs in your car, do it in a backpack or a duffel bag or a briefcase. As long as it's within arm's reach and in something that's movable, then storage can never be met. And so we would ask this court to reject that notion. And finally, if this court, and I believe, Justice Allen, that you're correct, that the dissent was only focused on storage, we think that this court, if it disagrees with the state and determines that the evidence in the light most favorable to it was not enough to get to substantial evidence on storage, this court could reverse and remand to the Court of Appeals with instructions to determine whether or not the evidence was sufficient for selling. Unless there are any further questions, we would ask this court to reverse on the MAR issue and affirm on the selling issue. Thank you, Your Honors.
Thank you, counsel. Clerk.
All rise. Yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 a.m. tomorrow morning. God save the state and this honorable court.